Good afternoon. On behalf of the Canadian Civil Liberties Association, I asked the question initially, what are the implications if the police can obtain this type of evidence or this type of data without prior judicial authorization? And I say that because our position is not that the police should not be able to obtain this information, this investigative data, but simply that it should be required prior judicial authorization. And that's all I'm here to ask the Court to impose. And I'll start out by asking another question, which is, if the appellant is correct that this type of data can simply provide information about whether or not there is a grow-op or whether or not there is a marijuana operation within a residence, then, frankly, I'll ask another question. Why is it that here in Ontario we have implementation of smart metering this year such that the Ontario government has said, and I'll take you to the materials, every utility subscriber in Ontario will have a smart meter installed by the end of this year?
You take as a threshold that a warrant should be requested before using that technique. But if this is an ongoing investigation and assuming that there are not enough grounds for searching the house, do you put a threshold that is lower for this technique than the one you would use for the search of the house itself?
In my submission, no, and I'll explain why. But the standard for search warrant is reasonable grounds to believe. And I'm not suggesting that you water down that standard at all in the circumstance, because as in my submissions I hope I take you to, the facts, DRA or smart meters provide very, very specific information about lifestyle. And just responding to a previous question in submissions today, I'm not going to suggest that DRA or smart meter data can provide information about necessarily such things as religion, about gender necessarily. What DRA data can show on the materials is, for instance, when one sleeps, when one does the laundry, perhaps when one turns on the TV. That leads the suggestion, France, when you're turning on the TV, you might like a particular type of TV show. If a particular TV show is very popular, 60 Minutes, 7 o'clock on Sunday night. Perhaps if you consistently turn your TV on Sunday night at 7 o'clock, that might yield a certain inference.
I thought Justice Martin, when he's describing what the role of DRA technology is, that it doesn't indicate the source of consumption, it just provides information as to the amount that's being used. Does that change your argument?
In my submission, the Court below didn't have available some of the materials that I put before this Court. So, for instance, the more recent Ontario Privacy Commissioner's report, which I put in my brief authorities, it's replicated in the condensed book of authorities at tab 2. So, for instance, the Ontario Privacy Commissioner notes that and this is the third paragraph into that page, page 8. Smart meter is a meter that can record and report electricity consumption information automatically, and that's an important feature. Smart meters identify consumption in greater detail than a conventional meter and communicate that information back to the utility company for monitoring and billing purposes. Smart meters will range in terms of interaction with utilities and the distribution component of the grid and relaying information on a daily, hourly, and real-time basis, and so forth. And she goes on to comment that smart meters are being implemented at this point in time. So,
can a customer waive that protection?
Well, this comes back to the question that was canvassed with my friend just prior in terms of the regulations. And I suppose that given that there is this heightened sense from DRA data about lifestyle, you've seen in the materials, it might even be able to tell what type of shoes you're washing. Given that, it's my respectful submission that in imposing a consent sort of requirement on the subscriber, it's my submission that the Court should be very careful to calibrate the consent that is given to what they're actually giving up. So, for instance, there's tremendous discussion previously about the regulations and whether or not Mr. Gomboc, by virtue of automatic provision in the regulations, gave up his privacy right to that which was monitored by the DRA. And my addition to that, minimal as it is simply to say that Mr. Gomboc, on the facts here, would not have known that there was a DRA put onto his subscriber, his utility. So, in other words, if we look at what the Privacy Commissioner, I think, reasonably says about what DRAs can show, and what we see on the facts of this case, it's electricity consumption on what they call a granular level. Can it be said that Mr. Gomboc understood, for all purposes, when he moved into his house and subscribed to the NMAX utility, that he was going to be giving up DRA data about his privacy right within the home?
If we pursue this line,
I was just going to say that the provision says that he can specifically give a request to the utility not to disclose. So if he's not sure about what may or may not be disclosed, he has an option, which apparently he didn't exercise in this case.
And just to respond to your question, Justice Rothstein, again, Mr. Gomboc could not have known at the time that he would be consenting to giving something which never existed. So can you interpret this regulation to say it provides for presumptive consent to DRA data when Mr. Gomboc subscribes to his electrical utilities? DRA didn't even exist. This regulation is framed in 2004. The DRA is put on as a result of this investigation a year later.
If we follow this line of thinking that when a customer, and quite often doesn't have a choice but to sign the contract, and what the customer would understand and what reasonable expectations that customer would have, in this case here, could it be said that the customer would not know that the utility company could look at how much he consumes and when, and would that not be part of, it's part of the relationship. It's not like you're not giving your consent that somehow this third party you're having a contract with would agree to do A, B, C, D for the police that is not part of the business relationship. But when it is part of the business relationship, wouldn't that not be something the customer would know?
Well, it's my respectful submission, Justice Chiron, that in that circumstance, again, Mr. Gomboc can reasonably understand, if he happens to read the Court's decision in Plant, that net monthly billing records may be provided. And I think that for purposes of law, we can probably assume prior to the implementation, prior to the advent of this technology, one could assume net monthly billing records are provided to the police. However, DRA data, and it's not even clear that it was in the mind of the legislature or anyone in 2003 when this regulation was passed. In other words,
pardon me, but I have doubt again that ammeters are really new devices. They go pretty far pretty far back in the electricity trade.
Well, it's my submission on reviewing this. For instance, I put before the Court, and in my minimal time, I won't take you to the article in the MIT Technology Review. They refer to experiments going on in 2001 at MIT. In other words, an MIT professor is now looking at this and saying, well, developing an algorithm. This is an unfailing technology, and I see that some of the response from the bench, but this is an evolving technology. And in my remaining time, I want to leave the Court with this thought. If there is no prior judicial authorization requirement on this type, first of all, then this Court leaves it to each municipality, each utility company, each province to determine what information will be disclosed. So there will be no uniform standards in terms of privacy over this, which I say discloses lifestyle. Secondly, as we know from all the materials that are put before you, I put before this Court, this data is streamed wirelessly to the utility company, which, as a civilian technology, is extremely laudable. It's the smart grid. It's how this society becomes more energy efficient. The problem with that, from a police, from a law enforcement purpose for criminal justice, is if there is no warrant requirement, that allows the police to wirelessly receive, without prior judicial authorization, all of this data without the knowledge of the subscribers, to filter through this mountain of data And it's my submission this is yielding now a mountain of data to filter through.
Can we look at it the other way in this sense, that more and more there are issues like that. Our privacy is given up when we apply for a credit card, when we sign on for a trip and so on. It seems to me the regulations here were addressing this issue of privacy. That, you know, I'm a utility company. I'll know a lot of things about you. I'm giving you the opportunity here to tick the box if you don't want me to share that information. Isn't that a good thing? Subject to the constitutionality of that approach. Shouldn't we give support that kind of?
It is good. And before I read the Ontario Privacy Commissioner's report yielding a very, very loud and very, very clear concern about the significant privacy implications of this, I would have agreed with that proposition, Justice Sharon. However, it's clear that it is not just the Canadian Civil Liberties Association which is concerned about the significant privacy considerations here. It's the Ontario Privacy Commissioner as well as any number of academics. And I see that my light is on, and when lights are on, I know what that means. Thank you.
The first point I want to make is to address